Deputy Cascone? Ladies and gentlemen, I'm going to ask you to step into the jury room for just one moment. I don't want to keep that annoying white noise on any longer. It'll just be a little easier if I send you back and resolve a couple issues we have. Can we just temporarily move this out of the way so I can
I'll move it.
eye contact with the lawyers? Okay. All right. Well, let me frame the issue, see if I can make sure I understand what the argument's going to be. I'm assuming at this time that the state's going to call a witness who will authenticate certain recordings by and between Mr. Shahade and Ms. Dippolito. Assuming that they are authenticated, which will have to be done by a witness, my understanding of the defense objection is hearsay and confrontation clause. Is that correct?
Yes, Your Honor.
Okay. All right, so respond. Now, obviously, anything that your client says is not hearsay. It's an admission. So
Correct, Judge.
the hearsay objection would not apply to anything that Ms. Dippolito said. So your hearsay objection necessarily must go simply to what Mr. Shahade has to say. Is that correct?
Yes, Your Honor.
All right. Mr. Williams,
Judge, if you look at the Waters case on page 18.
you have to give me the Waters case. No one's given me this.
I'll make Waters. I gave it to you. Those are two cases I gave to you earlier today, Judge.
Oh, in connection with the instruction?
Yeah, same two cases. Those cover both areas.
All right, which page are you referring to?
If you look at the second, it starts at the bottom of the first column where it says the Sixth Amendment Confrontation Clause provides that in all criminal prosecutions.
Well, again, page number.
It's 18. I'm sorry, Judge.
18 at the bottom, because there's numbering. You've got the Westlaw numbering and you got this numbering. I got it, 18, page 18.
Should say fast case on it. Is it?
Yes, it's page, but there's, yes. I think
I'm
I'm
going by the bottom page number.
All right,
So the bottom page number 18, it starts off with the Confrontation Clause.
got it.
And then if you just look to the top of the next column, the actual last sentence of the next column, it says the Confrontation Clause does not bar the use of testimonial statements for purposes other than establishing the truth of the matter asserted. In both these cases, that's what they said. They said the statements of the police officers and the statements of what other co-defendants or other witnesses said they relate to the defendant during these things. They were not offered. They're not hearsay. They were not offered for the truth of matter asserted. They were offered for effect on the listener. And they found there was no Confrontation Clause violation. We are not offering any of Mr. Shahade's statements to the defendant for the truth of the matter asserted. They're offered solely for effect on Ms. Dippolito, and her statements are non-hearsay.
Okay, Mr. Rosenfeld.
Judge, that is completely intellectually disingenuous. There's no way those statements are coming in regarding the act of solicitation for any reason other than for the truth of the matter asserted. I mean, they're bringing these statements in to establish that she had the intent to commit this crime. For the state to allege otherwise is, I mean, I'm trying to give an appropriate adjective here, but it's disingenuous. We all know why the state's trying to bring this in. You know, I think we do have a serious confrontation clause issue here, excuse me. The state has made no mention of whether they intend on calling Mr. Shahade. I believe they do have to call him. He is available. The state has made that clear. They spoke to him. You know, the state needs to be honest with this court and candid as to why they're actually bringing it in. And I'm sure this honor knows, and honor's well aware of the facts in this case, that the state is bringing this in for another reason. And that reason is not to show the effect on the listener. That reason is clearly to show solicitation. And there is no way around the fact that a juror is going to infer and can conclude that it's coming in for any other reason, which is beyond unfairly prejudicial for Ms. Dippolito, would necessarily violate her state and federal due process rights, Judge.
Okay, anything further, Mr. Williams?
No, sir.
Anything further, Mr. Rosenfeld? Hearsay, confrontation clause, right?
And Judge Jackson is the same, the Supreme Court case says the same thing.
Actually, I've dealt with this with other confidential informants.
And due process, Judge.
Okay.
And 403.
All right. Okay. Let me make sure I roll on all of them. 403, I don't think the statements are the probative value is not outweighed by the risk of unfair prejudice, so I don't think it's a 403 objection. I'm going to overrule the objection. That's why you have a cautionary instruction. The statements of the informant are not offered to prove the truth of the matter asserted, but with respect to the responses from the defendant. So I don't believe they're hearsay, and I don't believe there's a confrontation clause issue. They still have to be properly authenticated. They can't just come in. Someone has to authenticate them. But I do not believe that they're inadmissible based on hearsay or confrontation clause. You had a 403 objection. What was the other objection, Mr. Rosenfeld? Due process. I'm not sure it's an evidentiary. I think that gets back to confrontation clause. I don't think there's a due process violation. So I'm going to overrule the objection, assuming they can be authenticated. Now, when they come in, Mr. Rosenfeld, I assume there's several of these tapes.
Judge, through him, we're going to bring in 1, 2, 3, 4, 5, 7.
Okay,
You want to outline those for the court instead of numbering them?
candidly, the purpose of my question didn't require recitation of the number, but let me say this, Mr. Rosenfeld. When these tapes come in, anytime a tape's offered, I'm obviously going to look at counsel and say, is there any objection? If I'm assuming you're objecting to all of them to preserve your objection. If you say, as previously stated, then what I'll do on the record is I'll say, overruled over previously stated objection, unless you have a new objection. In other words, something new, it'll save you coming up and making the same argument every time. If you want to come up and make the same argument every time, that's fine. But I'm just saying, if I say admitted over previously stated objection, that means I'm overruling the hearsay and confrontation clause objection. So it's up to you as to how you want to handle it. You just have the opportunity to.
I'll just get up and I'll say, Judge, I'll renew all previous objections.
And I'll just say, okay, so it'll be admitted over previously stated objection, so it's preserved for your appellate record.
And in light of your ruling now, I am, I have to object to this instruction provided by the state, as Your Honor is well aware. The instructions, and this wasn't even adopted yet. Your Honor can give your own instructions that are more appropriate with the law and that preserve Ms. Dippolito's rights. And the issue I'm having here is that because, and this is the due process issue, Judge, because these statements are so unfairly prejudicial, this jury instruction will not protect her rights. There's no way around the fact that they're going to take these statements for the truth of the matter asserted. It's impossible.
That's the purpose of the instruction. The purpose of the...
I'm saying the instruction, I know what the purpose is. I'm saying it's too weak of an instruction. I mean, the evidence is so damning, there's no way this instruction will satisfy and properly protect her.
Well,
We need a stronger instruction.
The instruction only has one purpose. That purpose is, and there are standard instructions within the jury instructions that talk about admission of evidence for a specific purpose, okay? The only purpose of this instruction is to instruct them that with respect to any statement by Mr. Shahade, it's not being offered to prove that it was true. It's simply being offered to demonstrate any responses by Ms. Dippolito. It's not being offered for the truth of the matter asserted, is what this instruction is designed to do. And so I think this instruction, particularly in light of your objection, is required because they're not to take his statements as true.
No, my objection to it is that it's not strong enough to preserve her rights. I agree, an instruction is absolutely needed.
All right, well, what is it that you think would make it stronger, consistent with the purpose of the instruction? The purpose of the instruction is not to talk about 403 or anything else. The purpose of the instruction is simply with respect to the fact that they should not take Mr. Shahade's statements as true. They're not offered for that purpose. That's the purpose of the instruction. So in line with that purpose, how would you strengthen it?
Well, in light of the fact that you overruled my previous objection, my next, I guess the next remedy would be instead of you are not to consider, you must not consider. Something very strong. We have to be, I mean, Your Honor has to be as affirmative as possible to protect her rights.
You
Or
must not
under
consider.
any circumstances. I mean, this needs to be a strong instruction. The juror cannot have any confusion as to what they can use these tapes for.
But this is, all right. Anything further, Mr. Williams? All right, I'm going to give the instruction. This is the instruction that has come out of cases and was initially proposed by the Jury Instruction Committee to the Florida Supreme Court. I understand I can modify it because it's not a
Well, I mean,
standard.
it's advisory, and the Florida Supreme Court has said.
Every jury instruction is advisory. I'm still responsible for the ultimate jury instruction. So I understand that. What I'm saying is I think it's adequate, so I'm overruling your objection to it.
All right, just one other question, and one thing you didn't rule on earlier for purposes of the record. And real quick, in terms of the motion to suppress, I'd argued that the state was judicially stopped from asserting a contrary position. Are you?
I do not believe they're a stop. So when I overruled your objection, it overruled or denied the motion to suppress. It denied each of the elements raised in that motion to suppress.
Thank you very much, Judge.
Okay. Are we ready to proceed?
All right, Judge.
Okay. Not yet?
The sergeant just told me that they have the immediate door open again, and there's witnesses up there, so I told him to keep it shut.
Okay, but that's not an issue with the jury. Okay, all right. All right. Okay, let's bring in the jury.
Jury's entering.
All right, welcome back, ladies and gentlemen. I do apologize for the delay. State ready to call its first witness.
May we approach briefly?
Yes.
Notice one thing about this instruction.
State ready to call its first witness.
swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Thanks. Good morning.
Good morning.
Could you please introduce yourself to the jury and spell your last name for us?
Officer Moreno with the Boynton Beach Police Department. My spelling is Moreno.
And Officer Moreno, what do you do with the Boynton Beach Police Department?
I am a road patrol officer right now.
How long have you been there?
19 years.
And what kind of different assignments have you had while you're there?
I was a narcotics officer for 5 years, undercover work, drug arrests. I was a member of the SWAT team for 14 years. I was a sniper on the SWAT team for over 6 years. And then I was assigned to the Detective Bureau, where I was in charge and conducting investigations from misdemeanors, and then I got promoted to the homicide unit. And I was a homicide detective I was a detective for 8 years. And I was part of the major case squad.
Were you the lead investigator on the case with Ms. Dippolito?
Yes.
When did you get involved in the case?
I was actually contacted at home and asked to come in.
Do you remember what day it was?
It was August the 1st.
And was August the 1st of 2009 a Saturday?
Yes.
Had you received and been briefed from other officers about things that had happened the day before on July 31st?
Yes.
On August 1st of 2009, did you meet with Mr. Shahadi?
Yes.
And is that Mohammed Shahadi?
Yes.
And did you meet with him at the Boynton Beach Police Department?
Yes.
And at the Boynton Beach Police Department, did you have him place a few calls to Ms. Dippolito?
Yeah.
Overruled.
Did you record those phone calls?
Yes.
How was your relationship with Mr. Shahadi when he was there with you?
It was the first time me meeting him. Said I didn't know him. He provided us with the information. So we just began to conduct the investigation from the beginning.
Did you ever threaten him?
No.
Did you ever coerce him at all?
No.
Did you ever threaten to prosecute him?
No.
Did anybody around you ever threaten those things?
No.
Foundation speculation.
Overruled.
All right, let's get right to it. I'm going to go through a couple phone calls. When you recorded the phone calls, were you next to Mr. Shahadi when he was making the phone call?
Yes.
So were you able to hear them as well?
Yes.
When you wired his car for the meeting on August 1st, when he met with Ms. Dippolito at the mobile gas station at Congress and Boynton, or Congress and Gateway, were you able to listen to that conversation live?
Yes, but I was not the officer in charge of wiring the vehicle.
Yeah, you didn't wire it, but you could listen to it live.
Yes.
You heard it live. Were you actually at the mobile gas station in the area somewhere around there surveilling it as well?
Yes.
The recordings that we're about to hear, are they the exact recordings that occurred that you were listening between the conversations between Mr. Shahadi and the defendant?
I can tell you that after I hear him.
Before you guys went to, so on August 1st, on Saturday, when you first get involved, around 3:35 that day, did you have Mr. Shahadi call Ms. Dippolito and tell her that he would meet her?
Yes.
Around 4:12 p.m., did you have Mr. Shahadi call Ms. Dippolito and tell her that he was about 10 minutes away?
Yes.
And then a little after 4:15, is that when he arrived at the mobile gas station and you guys did the video recording of Mr. Shahadi and Ms. Dippolito together in his vehicle?
Yes.
Objection leading.
Sustained. You need to ask non-leading questions.
All right, then let's go with the first one.
Objection, may we approach?
Yes. All right, again, I apologize for the delay, ladies and gentlemen. There's a couple things we're going to have to do, and given the time, here's the most efficient way so that we don't waste any more of your time than we need to in connection with doing the things we need to do. And what I'm going to do is I'm going to go ahead and send you to a little bit of an early lunch. Usually we wait about 12 o'clock before lunch, but we'll bring you back at 1 o'clock and we'll be ready to proceed with the evidence at that time. A couple of things I want to tell you. First of all, with respect to the what you see on the easel here, I do want to give you an instruction. This is not evidence. This is what's known as a demonstrative aid. So this is not evidence in the case that you're to consider as a demonstrative aid. There may be demonstrative aids that the attorneys use throughout the course of the case, which is not evidence, but just a demonstrative aid. So we're going to let you go a little early so we can take care of some things. Instructions, I know you can probably repeat back to me verbatim. You can't communicate with anyone about the case. Can't do any research with respect to the case. And you obviously cannot listen to or read any news accounts of the trial. Deputy's going to take you out the back way. He'll ask you to be back outside those glass doors where you guys met this morning at 1 o'clock, and we'll be ready to proceed with the presentation of the evidence. Have a pleasant lunch. We'll see you back in an hour and 15 minutes. All right, you may be seated. Mr. Williams, how do you want to do this?
Just would like to be here. I'm just going to take him out.
Okay, I want everybody to be clear what we're doing.
I'm running through each piece of evidence with him.
Each disc is going to have to be authenticated, which means he has to hear what's on each disc and then be able to say that that accurately describes, you know what the authentication is, but he has to do it in advance. The attorneys obviously can be here. There's no, Mr. Claypool, Mr. Rosenfeld, do you agree this is not something I need to, it's not something that needs to be done in open court. He just happens to be here in open court when we're doing this. Is there any objection to a recess at this time while he goes through this process? You can listen to what's going on if you want, not listen.
Yeah, that's fine.
Okay, all right. Saying you don't have to be here unless you want to be here. So what we're actually going to officially be in recess, which means the court reporter doesn't have to take down what's going on either. This exercise is simply for the purposes of determining whether or not he can authenticate the tape. So we'll go ahead and recess the proceedings at this time until 1 o'clock. I will leave you the courtroom if you want to do it here in the courtroom. And Susan, it does not have to be taken down because we're in recess. Okay. All right, we're in recess.